Good evening and welcome to Skybridge Channel. Tonight's episode is a legal analysis report. Why the prosecution failed to prove guilt beyond a reasonable doubt in the Senzo Meyiwa trial. In October 2014, South Africa was stunned by the fatal shooting of national football. Captain Senzo Meyiwa at the home of his then-girlfriend, singer Kelly Khumalo in Vosloorus, Gauteng. More than a decade later, 5 men stand accused of his murder. Yet the state's case remains unfinished and rife with controversy. On 24th of July 2025, after 3 years of leading evidence, the prosecution formally closed its case, paving the way for a defense application for discharge under Section 174 of the Criminal Procedure Act. This report examines why the state ultimately has not, and arguably cannot, satisfy the high criminal standard of proof, guilt beyond a reasonable doubt, by assessing key legal arguments, testimony and credibility issues, and procedural and investigative shortcomings. Case background and timeline are as follows. October 26, 2014, Senzo Meyiwa is shot dead at the Khumalo residence in Vosloorus. 2014, 2020 cold case unit investigates criticisms over evidence handling and witness interviewing. June 2020, 5 suspects, Sibia, Antanzi, Mncube, Mafiza, and Tuli arrested. All plead not guilty. April 11, 2022, trial commences in Pretoria. High Court before Judge Chifiwa Momela, but suffers numerous postponements. In June 2023, trial restarts under retired Judge Ratha Mogolhang after Judge Momela's illness and suspension. July 24th, 2025, state completes its case after calling dozens of witnesses, including forensic experts, police investigators, and key eyewitnesses. Numerous controversies have marred the proceedings, including challenges to the admissibility of evidence and a high-profile public apology by Judge Mogolhang for a racist outburst during cross-examination of Advocate Minisi. Burden of proof requirements. Presumption of innocence. The 1996 Constitution entrenches the presumption of innocence. Everyone charged with a criminal offense has the right to be presumed innocent, to remain silent, and not to testify during the proceedings. Section 35(3)(h). This presumption requires guilt be proved beyond a reasonable doubt. In Wilmington versus DPP, the prosecution must prove every element of the crime, including actus reus or mens rea, irrespective of the accused's defense use of reverse burdens of proof in legislation, citation, marker reverse, onus or deeming provisions that risk convicting in the face of reasonable doubt are unconstitutional unless demonstrably justifiable under Section 36. The beyond a reasonable doubt standard is the highest in our law, reflecting the gravity of depriving a person of liberty. It demands evidence strong enough to remove reasonable doubts about guilt rather than a mere balance of probabilities assessment. In S versus Manamela, the Constitutional Court reiterated that the presumption of innocence rejects any risk of conviction despite reasonable doubt. Prosecution's legal theory and arguments: a premeditated hit, not a botched robbery. The prosecution maintains the shooting was a planned hired hit rather than a spontaneous robbery gone wrong. Key arguments include ballistic matching of the crime scene bullet to a CZ-75 pistol found in accused Mancube's cell, accused 3, confirmed by Cole Chris Manjana and peer-reviewed by Leolat Cole Cireo. Our cell phone records placing accused at the scene and communications with co-conspirators, based on expert analysis by Colonel Lamberto Stein and others, though some findings proved controversial and are subject to recall applications by the state. Confessions from accused. Antanzi and Sibia, whose voluntariness is disputed, forming the backbone of the timeline and motive. Prosecutor Beloy asserted that the amassed forensic, digital, and testimonial evidence cumulatively satisfies the beyond reasonable doubt threshold and invited the defense to call any unused state witnesses. Key legal arguments: Section 3 of the Criminal Law Sexual Offenses Amendment Act and Section 94 CPA. Some charges ancillary to murder, like aggravated robbery and firearm possession, use reverse onus provisions subjected to constitutional challenge, deemed inconsistent with the presumption of innocence in similar contexts. Action 2212 for CPA. This pathological report diagnosing old and fresh genital penetration was excluded because no proper foundation was laid to qualify Miss Makinana as an expert in anatomy and physiology. No explanation of her forensic nursing registration, peculiar skill set, or chain of qualifications, contrary to established requirements for expert testimony. Ballistics evidence. While expert analysts Mangina and Cireo convincingly matched the crime scene bullet to the pistol in Mencube's possession, defense cross-examination raised legitimate questions about primer residue tests, cartridge ejection patterns, crime scene tampering allegations, and the reliance on unverified cell phone expert evidence, introducing doubt as to the reliability and chain of custody. Forensic and crime scene shortcomings. Crime scene integrity. Mosia's testimony exposed numerous lapses. Failure to expedite crime scene processing. He left uncovered scene for unrelated tasks, then returned to find evidence arguably moved. No systematic primer residue testing of actors in the scene and delayed discovery of the bullet fragment, subsequently doubted as planted or tampered with by defense experts. These factors undermine confidence in the prosecution's physical evidence narrative. Cell phone records section 205 discrepancies between Colonel Stein's initial testimony and section 205 data prompted a recall application, revealing inconsistencies that could not be reconciled in the prosecution's digital evidence chain. Procedural management and trial delays. Protracted duration. Unreasonable delay. Legal experts such as Dr. Bangani and Kosi and Elton Hart have repeatedly raised concerns about the trial's 10-plus year odyssey, attributing it to judge changes, frequent postponements, voluminous evidence presentation, and counsel availability issues. These delays risk witness attrition and evidence degradation, contrary to the constitutional right to trial within a reasonable time. Courtroom disruptions. Judges' outburst. Repeated friction, most publicly Mogodelhang's racist remarks and subsequent apology undermines confidence in judicial impartiality, potentially affecting trial management and prolonging proceedings through recusal threats and public backlash. Accused transfers and shackle disputes. Allegations by Ntuli of torture at Kagosi Mampuru and demand for transfer to Leukop disrupted the court, delaying evidence and intensifying administrative burdens, as the judge had to hear correctional services undertakings and order formal rescission applications instead of immediate hearing continuance. Investigative shortcomings. Initial crime scene response. The initial securing of the scene in Vosloris was deficient. No immediate scene lockdown or preservation of fragile evidence. Unexplained disappearance or late recovery of the bullet fragment. Insufficient witness interviewing protocols, exacerbating hearsay reliance. Coercive tactics allegations. Accusations by Sibia and Ntuli that police used torture, threats, and false promises to extract confessions led to a trial within a trial on voluntariness, diverting resources and undermining prosecutorial credibility. Section 174, Discharge, Defense Strategy, Legal Framework. Section 174 of the Criminal Procedure Act permits discharge if no evidence upon which a reasonable court might convict remains after the state's case. The Supreme Court of Appeal in Lubaxa reaffirmed that discharge is mandated if conviction would depend on self-incrimination alone, which is incompatible with systemic fairness and dignity rights. Anticipated grounds. The defense will rely on absence of credible evidence linking accused to the murder, inadmissibility of key forensic pathology and testimonial MD evidence, hearsay deficiencies in the chain of information, crime scene mishandling warranting exclusion of real evidence under constitutional and common law discretion, legal aid's impending funding decision, to be heard 7 60 August 2025, will be critical for pursuing this strategy. Judicial observations and impact on public trust, impartiality and public confidence, judicial admonitions and public scandals, particularly Mogodelhang's racist outburst and subsequent apology, have fueled perceptions of bias. Under FCS 165, courts are empowered to regulate their proceedings. Yet such incidents necessitate rigorous self-examination to maintain legitimacy and adherence to constitutional values, balancing rights and expediency. While the accused's rights to silence, presumption of innocence, and fair trial must be zealously protected, the state must also ensure efficient prosecutions. Reasonable timeframes, robust evidence-gathering practices, and judicial discipline are essential to striking this balance. Conclusions and recommendations. The prosecution in the Senzo Meyiwa murder trial has presented a voluminous but flawed case. Critical evidential gaps from expert qualifications and child witness testimony to crime scene integrity and hearsay chains, coupled with procedural mismanagement, render a verdict beyond a reasonable doubt unachievable. The defense's forthcoming Section 174 discharge application is likely to succeed in ending this prolonged and traumatic process for all parties. My recommendations are as follows. 1. Prosecutors must ensure the rigorous foundation for expert testimony and forensic evidence, including documented qualifications and chain of custody protocols. 2. Investigative agencies should adopt stringent crime scene preservation guidelines and immediate witness interview protocols to reduce reliance on hearsay. 3. Courts should enforce strict timelines and limit postponements. Introduce administrative reforms to minimize unforeseen delays. 4. Judicial officers must maintain impeccable impartiality with mandatory diversity and sensitivity training to prevent reputational harm. Ultimately, justice for Senzo Meyiwa's family and public confidence in South Africa's criminal justice system demand a transparent, efficient, and constitutionally compliant trial process. Only by confronting these failings head-on can future high-profile trials avoid similar miscarriages of justice. Do you think the state has proven its case beyond reasonable doubt? Should the accused be acquitted under Section 174? Let me know your thoughts in the comment section down below. Share the video far and beyond. Hit that like button and remember to subscribe. Skybridge checking out. See you in the next episode. Bye.